Hello everyone, welcome to Lecture 3 in the Insurance Lecture Series entitled Concealment and Representation. Concealment is a neglect to communicate that which a party knows and ought to communicate. Each party to a contract of insurance must communicate to the other, in good faith, all facts within his knowledge which are material to the contract and as to which he makes no warranty, and which the other has not the means of ascertaining. While representations are statements made to give information to the insurer to induce him to enter into the insurance contract. Representations may be in writing or by word of mouth. While the insurance code dispenses with proof of fraudulent intent in cases of rescission due to concealment, the code requires fraudulent intent in cases of rescission due to false representations. In one case, the Supreme Court held that a mere health statement form bearing a wrong birth year should not be relied on. The insurer is obligated, under the circumstances, to make further inquiry. A single piece of evidence hardly qualifies as clear and convincing. Its contents could just as easily have been an isolated mistake. Only material facts are required to be disclosed. Materiality is to be determined not by the event, but solely by the probable and reasonable influence of the facts upon the party to whom the communication is due, in forming his estimate of the disadvantages of the proposed contract or in making his inquiries. So the principal question, therefore, must be, was the assurer misled or deceived into entering a contract obligation or in fixing the premium of insurance by a withholding or falsely representing of material information of facts within the assured's knowledge or presumed knowledge? The following are examples of material concealment. In one case, the Supreme Court held that the uncontested removal of the machineries to another location put the machineries at the insured company's own risk. In another case, that the insured still had his pacemaker when he applied for insurance is an admission that he remained under treatment for irregular heartbeat within 5 years preceding that application. Also, concealment of fainting spells and/or drug overdose illness in life insurance is considered material. Note also that causation is not necessary. The insured need not die of the disease if he had failed to disclose to the insurer the existence of such disease. In one case, the claim was denied on the ground of concealment of diabetes, although the insured died of blood poisoning. The following are examples of material representation. When the insured in a life insurance policy falsely represented that she had not smoked for 1 year. When the applicant in a life insurance policy stated that she weighed 180 pounds when she in fact weighed 300 pounds. Notably, a provision that if the age of the insured is considered in determining the premium and the benefits accruing under the policy, and the age of the insured has been misstated, the amount payable under the policy shall be such as the premium would have purchased at the correct age. Also, misdescription of the building, without the fault of the insured, cannot be considered material representation. Statements of value are of necessity, to a large extent, matters of opinion. A party may rescind the insurance contract if the following requisites are present. 1. The party involved must know the fact concealed or falsely represented, or at least he ought to know the same. False representation must establish fraudulent intent. 2. The fact concealed or falsely represented must be material. 3. No warranty is extended by the party regarding the fact concealed. And 4. The other party does not have the means of ascertaining the facts concealed or falsely represented. Rescission is unavailable in the following cases: when there is waiver, when an action has already been commenced on the contract, and finally, when the incontestable clause applies. So here's the summary of the distinctions and similarities of concealment and representation. While concealment involves an omission or non-disclosure, representation involves a positive assertion or affirmation. While concealment cannot refer to future acts, representation can pertain to the future because it can be promissory. In concealment, fraudulent intent is not essential, while in representation, fraudulent intent must be established by clear and convincing evidence. In both concealment and representation, same test of materiality applies, and a party can rescind the insurance contract. Notably, an insurer can still rescind the policy even if it accepts the premium despite the knowledge of the ground for rescission, provided that the other defenses are not available, like the incontestability clause. So that's it for today's lecture. Thank you so much for listening.